Mr. Russell.
I'm grateful, my Lord. But before I move on to the next topic, I thought I might just show you a passage in the judgment in The Good Friend that I referred to but didn't have the reference immediately to hand. It's at bookmark 71, page 1113. This was a case in which there was a residue of previous cargo left on board the vessel after the discharge of the previous cargo. That cargo had an insect or the residue had an insect infestation in it, and the infestation from the previous cargo meant that the vessel was unable to complete the contract of carriage and discharge the cargo at Havana in Cuba. So I say the judgment starts at 1113, and there's quite a helpful discussion of the principles governing on seaworthiness, starting at 1118. And I don't propose to read it out or invite your lordships to read it now. It runs over 3 pages to 1120. And in that passage, Mr. Justice Stoughton discusses the cases involving safety and the physical risk to the cargo, then discusses the cases where there's a legal impediment which may result in physical damage, such as Chiampa and the Macedonia, or the Madeline rather, and then refers at 1120 to the Aqua Charm, and really contrasts the fact of the Aqua Charm involving simply a temporary or minor impediment with the fact of the Good Friend case, where the infestation meant that it was impossible to complete the contractual voyage and discharge at Havana. But I say it's quite a helpful analysis, and sort of draws the different strands of cases together and gives an explanation of the Aqua Charm in terms of it being a case where there's no physical risk or lack of safety to the vessel or the cargo, merely a minor and temporary impediment. And of course, it may well be that it's a question of fact in each case as to whether an impediment to the prosecution of the voyage is sufficient to constitute unseaworthiness or not. So, common ground, key concessions or points that can't sensibly be disputed. And as I said earlier, it is important to remember what is conceded and is common ground in this case, because there are a number of aspects of my friend's argument which really seem to us to be inconsistent with the concessions that have been made. The following key points are common ground. Firstly, that the regimes in 3.1 and 4.1 on the one hand, and 3.2 and 4.2 on the other, are separate regimes in the sense that the 4.2 exceptions are not defences to a claim for a breach of Article 3.1. If the vessel is causatively unseaworthy, the owner's only defence is to show that they exercised due diligence, but that the vessel was unseaworthy notwithstanding the exercise of due diligence. And that is obviously a fairly trite proposition following the Maxine case, and unsurprisingly, it's expressly agreed as common ground in the statements of facts and issues at paragraph 24 at page 11 of the bundle. My learned friend, in his written case, also accepts that navigation and management of the ship are, in principle, to be treated in the same way as each other. And one can see that at paragraph 106 of the written case, which is at page 41 in the bundle. And it's worth turning up page 41 because in paragraph 107, there is what we say is a really crucial concession. And paragraph 107 says, in practice, a managerial decision is unlikely in itself to render the ship unseaworthy. It is more likely to be part of the causational background, i.e. to result in a defect in an attribute of the ship. The same analysis holds true for navigational decisions. They are capable of causing unseaworthiness, but do not themselves amount to unseaworthiness. Now, we don't accept the second part of that proposition. We don't accept that a navigational decision cannot in itself constitute or amount to unseaworthiness. But for present purposes, the key concession on the part of the owners is that navigational decisions are capable of causing unseaworthiness. And even if you put the owner's case at its highest, that is what has happened in this case, because the navigational decision, if that's how you want to characterise it, of failing to put the depths warning on the chart has caused the vessel to be unseaworthy, because it has caused the vessel to have a defective passage plan and a defective and unsafe chart on the chart table on departure from Jamen, as per the judge's findings of fact. So if you take the judge's findings of fact that the chart was defective absent the warning, that inconceivable that any prudent owner would allow the vessel to go to sea with the chart in that defective condition, and you combine that with the concession that a navigational decision is capable of causing unseaworthiness, then that's fatal to the owner's case.
Why don't you accept the last sentence of that? Surely a navigational decision can't itself be unseaworthiness, because unseaworthiness is a state of affairs.
Well, I accept that there has to be a state of affairs. Let us say that before the voyage commences, the master takes a navigational decision that he is going to take a bad route, an unsafe route that's going to go across a shoal. And leave aside for the moment whether it's written down or not. The master's state of mind is that he is going, his intention is going to take an unsafe route. In my submission, that does constitute unseaworthiness. That formulated intention in the master's mind is such a state of affairs that if the prudent owner were aware of it, he would not permit the vessel to go to sea, that state of affairs pertaining. It's no different from a master who is, before the voyage commences, has taken a bribe from drug smugglers and is going during the course of the voyage to deviate to take on drugs. That is something that is in the master's mind. It's a disinclination to perform his contract of employment, perform the contract of carriage, because he's formulated that intention to deviate to rendezvous with the drug smugglers. And if the prudent owner knew about that, he wouldn't allow the vessel to go to sea. It's, in my submission, in principle no different if he's taken a navigational decision for navigational reasons, if it's negligent, rather than a Barrettist decision such as that. But of course, that isn't our case, because here we have clearly unseaworthiness in the passage plan and the chart itself. You can see a concession to similar effect on page 43. Paragraph 111, subparagraph 3, And this is discussing Lord Justice Flo's reliance in the Court of Appeal on the DeBell and Rossmore case. And the case says Lord Justice Flo's reliance on this case is misplaced because it addresses the straw man point of whether defects caused by an act of navigation and management cannot render a ship unseaworthy. This argument was not and is not the owner's case. Well, we'll have to come back and discuss what the owner's case is if it's not that. Throughout, my friends, oral submissions, he kept making the point that the passage plan is simply a record of navigational decisions. But as I say, 107 is an express concession that navigational decisions can cause unseaworthiness. And similarly, paragraph 37 this is in paragraph 94 of the case, which is discussing the Maxine footwear case, and subparagraph 5 of that paragraph at the top of the page. The reason this decision, that's the reason that the Maxine footwear decision does not advance the matter, is because owners do not seek to argue that Article 3.2a exceptions apply where the ship is unseaworthy, but that unseaworthiness is caused by errors in management or navigation. But again, while that concession appears quite clear and unambiguous and unfettered there, nonetheless, you have the argument that in some way the unseaworthiness obligation is shaped by the 4.2a exception, because that in some way provides context for the unseaworthiness obligation. In our submission, that's just not right. And then there is a concession that's made that if the vessel doesn't have the right charts on board or they're not properly corrected, then the vessel may be unseaworthy. And that's made in the case at 135. It's most clearly seen in the judgment in the Court of Appeal, paragraph 82 of the judgment of the Court of Appeal, page 142 in the bundle, and 142 in the bundle. This is in the judgment of Lord Justice Mayles. It says, Mr. Hill accepted inevitably that charts which are not up to date will render a vessel unseaworthy, but submitted that updating a chart is a purely mechanical exercise which consists of nothing more than following precise instructions in a notice to mariners. And there's no attempt, as I understand it, to resile from that inevitable concession that was made in the Court of Appeal. Owners, of course, also accept as a matter of principle the non-delegability principle established in Maxine Footwear, DeBell and Maxine Footwear and Muncaster Castle. Though there's obviously the attempt to carve out the situation where the master or crew are acting as while navigators. And as to that, obviously, we say there's no basis for any carve out at all for the reasons that I gave when we were looking at the cases. So, what's left of the owner's case, given those concessions? What is their case? As a preliminary observation, the owners in this case have to identify an error of law in the judge's approach. They can't simply say that the judge got it wrong on the facts. So that there has to be an error of law. What is the point of law that is relied on? In the written case at page 19 in the bundle, paragraph 14, they refer to... So sorry. Yes, page 19, paragraph 14. So in the first ground of appeal, owner's position is that a defective passage plan does not render a vessel unseaworthy because the seaworthiness obligation gives effect to a category-based distinction between the carrier's responsibility to equip and man the vessel and instances of negligence in the navigation of the vessel by a competent crew that has been adequately equipped, for which the carrier is not responsible. But the reason why I took you to the concessions first is they've conceded that there is no such sharp category distinction because a negligent navigational decision can cause the vessel to be unseaworthy. And we've looked at the cases that make it very, very clear that the carrier's responsibility is not simply to equip and man the vessel. The carrier's responsibility, personal and inescapable, whether the work is done by the carrier itself, by its servants or agents or independent contractors, including specialists, the carrier's responsibility is to exercise due diligence to make the vessel seaworthy. And there simply is no basis for a category-based distinction to limit the scope of the unseaworthiness obligation, the concept of unseaworthiness, as it has been understood throughout the ages, both before any statutory regulation at common law, in the Harter Act in the US, and pursuant to the rules themselves, and now the Hague-Visby iteration of the rules. So, on the one hand, they accept that there is no category-based distinction, but then seek to resile from their own concession. Once it's accepted, both that negligent navigation can cause unseaworthiness and that defective charts can cause unseaworthiness, the only argument as a matter of law can be that there's some subcategory of negligent navigation or some subcategory of defective chart that, as I say, as a matter of law, cannot constitute unseaworthiness, even if the McFadden prudent owner test is satisfied. But in my submission, it's completely impossible to try and isolate, as a matter of law, such subcategories. And when you seek to draw out some sort of principle from the argument, it really does seem to come back to the argument that there's a difference as a matter of law between the correction of a chart, which is done in pen as a result of mandatory directions in notices to mariners, and the more discretionary annotation of a chart in pencil, transcribing warnings from notices to mariners that are not mandated by the terms of the notices to mariners themselves. But that cannot, as a matter of law, be a principal distinction, because the only relevant question is whether, at the end of the day, the chart is safe for use in navigation or not. If there's a warning in the notice to mariners that has to be put on the chart for it to be safe for use in navigation, it surely cannot make a difference to where liability under 3.1 falls. That in one case, the notice to mariners says expressly, write this on the chart, and in the other case, the notice to mariners doesn't say expressly write it on the chart, but it has to be written on the chart, as a matter of fact, for the chart to be safe. So we say that there is no support anywhere to be found for this supposed category-based distinction. Even the thinned down version of the category-based distinction that is being run in the light of the express concessions that I've taken you to. The first argument seems to be the category-based distinction. Secondly, there is the attributes argument, and there appears to be two parts to the attributes argument. The first is that, and we see this at paragraphs 125 to 133 at page 45 in the bundle. So it's page 45, and it starts at paragraph 125. It said that a navigational decision is ephemeral and not an attribute of the ship for that reason. And then at page 47, it said that, if we look at the heading again, it said that a passage plan isn't an attribute of the ship because it's merely a record of navigational decisions. Now, as a starting point, we obviously don't accept that there is an attribute threshold at all. If it goes beyond saying that what the relevant defect or state of defect or state of affairs must in some way relate to the ship. I'll come back to the authorities on attributes in a moment. As to the ephemeral point, a defect may be so easily and readily remediable that a prudent ship owner would expect the crew to remedy it, if necessary, during the course of the voyage. And if that's the case, it is not necessary to have it remedied before departure to make the vessel seaworthy. On the other hand, the circumstances may be such that the prudent owner does require the defect to be put right before the beginning of the voyage. And you see that in the porthole cases. If the porthole is easily accessible and it is reasonable to suppose that it will be closed at the first sign of bad weather, the vessel is not unseaworthy at the commencement of the voyage because the prudent owner would say to himself, well, my competent crew will shut it when the wind gets up. But if it is inaccessible and it is going to be problematic to close during the voyage, or it cannot be anticipated that the crew will look at it during the voyage, then the open porthole may cause the vessel to be unseaworthy because the prudent owner would require it to be shut before the beginning of the voyage. But this isn't a distinction as a matter of law. Those are distinctions as questions of fact and are simply an application of the McFadden test. So to say that a navigational decision is ephemeral doesn't assist in trying to identify a point of law that would suggest that the judge was wrong. In any event, of course, on the facts of this case, the navigational decision, if that's what it was, not to put the warning on the chart and in the passage plan, was not ephemeral at all. It meant that the document that was being used to navigate the vessel on the outbound passage was defective and unsafe and was causative of the casualty. In the second part of the attributes argument, which is at 134 and onwards, this is the section where an attempt is made to distinguish between the base chart and the working chart, and to argue that the base chart is an attribute of the vessel, but the working chart is not an attribute of the vessel. But they're the same document. There is only one chart on the chart table. And to suggest that it has two different existences in some way is, in my submission, wholly unsustainable. it's not right, certainly certainly on the facts of this case, to characterise the relevant defect as being the manifestation of the master's navigational intention, because the defect in this case was not the manifestation of any navigational intention. The defect in this case was the absence of the warning on the chart, which would have served to prevent the master from making a bad navigational decision in real time as he was seeking to execute the passage from Jamen. But as I discussed earlier in the course of my argument, even to the extent that the passage plan is simply a manifestation of navigational intention, it's still an attribute of the ship, because it is the guide pursuant to which the vessel is going to be navigated. It's the tool which the navigators on the bridge at any given time are going to use to navigate the vessel. And then the third strand of argument that emerges from the written case in relation to unseaworthiness is that the owners say that the vessel was not unseaworthy because she was competently manned and was equipped with everything needed, everything that the crew needed to make the vessel seaworthy. But for the reasons that we've looked at in the authorities, that's simply wrong as a matter of law. Carrier's obligation is not limited merely to manning, equipping and supplying the ship, which is the Article 3.1b obligation. The carrier is also required to exercise due diligence to make the ship seaworthy, Article 3.1a. And the essence of that obligation is that the carrier is required to do everything that's necessary to prepare the ship for the voyage, to make it safe for the voyage. It's non-delegable and has to be done via master, the crew, other servants or agents, independent contractors, and so forth. We've got to remember that this is, we're still looking at the unseaworthiness stage. It's a binary choice. If the vessel has a defective passage plan, a fortiori, we would say defective chart, the vessel is unseaworthy, even if the master and crew had the means to remedy the defect. Now, that third argument that is advanced in relation to unseaworthiness is obviously also advanced onto the second ground of appeal in relation to due diligence. And there, again, it is wrong, but it's been an argument that's been run in numerous, well, it's been run in some of the early cases, in particular the Muncaster Castle, and has been roundly rejected by the courts. It's not enough for the owner to discharge the due diligence obligation to man and equip the vessel and provide all that's required if those servants and agents to whom the task of making the vessel seaworthy has been delegated, if they don't exercise due diligence, then the owners don't discharge the burden that is on them to demonstrate that there has been no want of due diligence. And I've taken you to the Orbit cases. And they're, of course, important because the second limb, if you like, of the argument in relation to due diligence is the qua navigator, qua carrier point. And for the reasons that I gave earlier, that doesn't run. The Orbit analysis doesn't help, can't help the carrier, because the task of making the vessel seaworthy, including preparing the passage plan, including making the working chart safe for use in navigation, are all tasks that are within the carrier's orbit and within the carrier's area of responsibility, and have to be performed on the carrier side of the fence within the carrier's orbit to enable the carrier properly to perform the contract of carriage. And indeed, if one thinks about it, the fact that these navigational tasks are within the carrier's orbit and are matters for which the carrier would be responsible explains why the carrier had to stipulate for the 4.2a exception to apply after the voyage commenced. If the acts of navigation of the master are out with the carrier's area of responsibility, the carrier might simply have been able to argue, I'm not in breach of Article 3, Rule 2 if the master does something negligent, because I'm not responsible for the negligence of the master. That's outside my orbit. That would have been a hopeless argument, though, in the same reason that we say that the argument under 3.1 is hopeless. But it's because it would have been a hopeless argument that the ship owners stipulated for the 4.2a exception, so that they are excused for the negligence of the master and crew in the navigation and management of the vessel during the course of the voyage. But of course, that doesn't impact on the scope of the 3.1 obligation.
The travel preparatoire might confirm that or support it in the sense that the owners and cargo agreed that the owner should not be liable for those things over which the owner didn't have control. I assume any time until the ship leaves the berth, the owner can in fact run along and say you're not going.
Well, historically, I mean, if one goes back into the mists of time, that is the genesis of the theory. Because if the you know, in times gone by, the vessel owner would be there, you know, overseeing the vessel and selecting the master and crew for each voyage before sending them off and waving the tear-stained hanky as his precious ship and cargo sailed off. But thereafter, the owner wasn't responsible. And of course, you know, the landscape is changing, changes all the time, because there are now many more cases when cargo can argue that even during the course of the voyage, there's been a personal breach of 3.2 by the carrier, because decisions that previously would have been left exclusively to the master because the carrier wouldn't have known what was going on are now decisions which may be taken by head office, because there's constant communication between the master and head office. So there may now be more argument as to whether a particular act is simply the act of the master or crew and caught by the exception, or whether it's also an act by the carrier himself. But of course, none of this impacts on the question of whether the carrier is liable for the want of due diligence on the part of his servants and agents before the commencement of the voyage, and we say that is very well established on the authorities. And in relation to this, if I may just take you to the judgment of Lord Justice Mayles in the Court of Appeal, because it really deals with it impeccably, if I may say so. It's in bookmark 5. Page 143 is where we pick it up. Paragraph 89 and following. And obviously, Lord Justice Mayles is someone who has been steeped in the rules throughout his legal career and has an innate understanding of them. And in this section, he refers to the principle of non-delegability. Then at paragraph 90, refers to the submission that the principle of non-delegability only applied to work performed by the master and officers qua carrier and not qua navigators. And 91, he says, I do not accept this submission. the FJ demonstrates that it's untenable. The errors in that case were by the master and were beyond the ship owner's practical control, but the ship owner was nevertheless liable as a result of the master's failure to exercise due diligence. If you remember from the judgment, it said in terms that it was the master's responsibility to calculate the distance that was to be run. And then Lord Justice Mayle says, in any event, the supposed distinction between work undertaken qua carrier and qua navigators to make the vessel seaworthy is illusory. If the vessel is not seaworthy for whatever reason, there's a danger that the cargo will not be carried safely to its destination, as in this case. And he then goes on to discuss the orbit of responsibility cases. And so we have the Anglis, which is the shipbuilding case. The negligence of the shipbuilders is out with the orbit of the carrier. And then at 94, he refers to the Captain Sakharov. And 95, he says, so the Captain Sakharov is the dangerous cargo, and the carrier not being responsibility of unlimited time, place, and person on the lack of due diligence on the shipper's side. 95, I do not doubt the correctness of this decision, and the orbit metaphor may sometimes be helpful, but it is evident that this decision is far removed from the facts of the present case. The relevant function was not the relevant function, that's in the Captain Sakharov, the relevant function was not the shipper's responsibility at all, but the shipper's. Then he discusses the Happy Ranger, which, as he says, is an application of the Anglis case, where a crane was defective and was defective as a result of the negligence of the manufacturer of the crane before it came into the carrier's orbit. And then the conclusion is on page 145. On the facts, however, that's the facts of the Happy Ranger, the ship owner was held liable because it failed to discharge the burden of proving that it exercised due diligence to make the vessel seaworthy after it acquired it. And then his conclusion in this case, in the present case, the task of making the vessel seaworthy for the voyage in the relevant respects was entrusted by the ship owner to the master and officers. It was nobody else's responsibility, and there was no question of a defect existing from a time before the ship owner had control of the vessel. There is no case in which a failure of due diligence by the master and officers has been held to be outside the orbit of the ship owner's responsibility. And it is hard to think that there could be. And really that's the point that I was seeking to make earlier when I was referring to the Venn diagram analysis. Everything that the master does is it's a small circle within the larger circle of the owner's responsibility. And therefore, the owners will be responsible for any want of due diligence on the part of the master.
We did have the example this morning of the master's decision in port to change the course. Your answer was, well, you'd have to update the chart, the passage plan. The actual decision to change course, even if made in port, would be the master's.
Yes, but if the, as I said, I think I said in response to a question from Lord Legate, if a decision is taken and the master has a bad plan in mind, that in itself, in our submission, will make the vessel unseaworthy, because there's a state of affairs exists which is unsafe and which the prudent owner, if he knew about it, would not allow the vessel to go to sea without it being put right. But obviously it's going to be, in cases like that, it's going to be a question of fact. And there are then also going to be causation arguments that are going to arise on the particular facts of a case.
So what about the continuing seaworthiness case? Changes his plan during the voyage. Does that make it breach?
Yeah, cases where there's a continuing duty of unseaworthiness are potentially more problematic than the Hague Rules case. In my submission, if at a point in the voyage the master forms an intention which is unsafe, that would make the vessel unseaworthy. In the same way is that if you have a passage plan that is safe at commencement of the voyage, but circumstances change such that it becomes unsafe, the passage plan has to be changed at that point, otherwise the vessel will be unseaworthy. But it's difficult to answer questions like that in the abstract, because in cases where there is some form of ongoing warranty of seaworthiness or duty to maintain or so forth, you have to look at what the nature of the obligation on the part of the owner is in relation to unseaworthiness. There are can't think of contractual terms where there is certainly an absolute ongoing warranty of unseaworthiness.
It's still due diligence, but
yeah. But
if
even
he negligently changed the passage plan during the voyage, it's a continuing warranty. In your case, that would be a breach.
At that point, the vessel would be unseaworthy. The question is whether it's in breach. Obviously, depends on the nature of the obligation. Yes.
When you say nature of the obligation, it's due diligence, and he's negligently changing the plan.
If the hypothesis is that there's an ongoing obligation to continuously exercise due diligence,
yes,
and the passage plan is negligently changed to one which is unsafe, then there is a breach. But that is on the hypothesis of a continuous due diligence obligation. And there's obviously a lot of scope for argument in cases where there are continuing obligations as to how when and how the due diligence obligation works out. But if the hypothesis is a clear, continuous obligation to exercise due diligence, then that would be the consequence. In the same way as if there is a continuous obligation to exercise due diligence to keep the vessel seaworthy, and the master adjusts the ballast during the course of the voyage to render the vessel unstable, then there would be a breach of the warranty as well, or the obligation as well. Now, it's where you don't have. I mean, this is a good example of how the same act under the rules leads to different liability outcomes depending on where the act takes place. If you have negligent ballasting such that the vessel is unstable before departure, the vessel is unseaworthy at the beginning of the voyage, and the owners are liable. See the Friso. If the Friso had left the port to commence the voyage with a proper stability calculation and the bottom planks pressed up so that she was stable, there would have been no breach of 3.1. Assume that the master then subsequently during the course of the voyage alters the ballast in such a way as to render the vessel unstable and she capsizes. It's the same act, the improper ballasting of the vessel. But in the second case, because of the temporal limitation on the seaworthiness obligation, the owners aren't liable because they're protected by the exception in 4.2a. Now, again, taking the hypothetical example of a continuous obligation to exercise due diligence, if the master in that case alters the ballast in such a way during the course of the voyage to render the vessel unstable, then the carrier would be liable.
We don't have to explore these outer possibilities, but on your case, as I understand it, if the master simply, during the voyage, changed course negligently, that would render the vessel unseaworthy, according to you. You basically collapse any distinction between state of affairs and acts, because if the master forms an intention, decides to do something, that's enough on your case.
Well, you then make it into a metaphysical argument as to whether when a decision becomes a state of affairs. But certainly for present purposes, if there's a settled intention, a fortiori, if recorded in a plan, that the vessel is going to go in a particular intention, direction, that certainly constitutes a defect for the purposes of 3.1.
But you don't need to go that far.
We don't need to go that far, because in this case we've got a defective chart sitting on the chart table. It's not safe for use in navigation.
But does it have to be a physical thing which is defective?
No, the cases make clear that where documents are missing that are required for the safe legal prosecution of the voyage, the vessel is unseaworthy. That's Levy and Coston, Farrandock, cases like that. And then you have the Chiampa, which is the plague port case, where simply the trading history of the vessel renders the vessel unseaworthy. That's why we say there are no conceptual limits to the nature of the defect or state of affairs that can cause unseaworthiness.
But I thought you emphasised the temporal limitation of Article 3.1.
Yes.
To the obligation arising before and at the beginning of the voyage.
Yes.
So if there were a change of course during the course of the voyage, which was going to take the ship onto shoals, for example, that wouldn't be within the scope of Article 3, Rule 1.
No, absolutely. It certainly wouldn't lead to liability under 3.1. As I understood the question I was being asked by my Lord Legate, it wasn't, do you say that leads to liability under 3.1? Absolutely not.
No, it's only about the concept of seaworthiness.
It's just what the outer limits of the concept of seaworthiness are. So that's the question.
That's what I was asking, on the assumption that we were dealing in another case with an obligation that continued during the voyage.
Yes. But I mean, the cases, the charter party cases where there are continuing obligations of seaworthiness and due diligence to exercise seaworthiness, they are different, because you then would have to look at the exceptions in those cases and construe the charter party to determine whether contractual exceptions in those cases applied to the due diligence obligation or not. I mean, ex hypothesi, we're not talking about a charter party that simply incorporates the Hague Rules, because the Hague Rules don't have a continuing obligation to exercise due diligence. The reason, or one of the reasons, why the 4.2a exceptions don't attach to the 3.1 obligation is because it's not a continuing obligation of due diligence. If there is a continuing obligation to exercise due diligence to keep the vessel seaworthy, then as a matter of construction of that contract, there may be a different answer to the question whether whatever the contractual exceptions that are incorporated or set out are, whether they apply to the due diligence obligation or not. So that may, I mean, if the concern is that it's imposing an impossibly high standard on owners, it may well be that the answer is to be found in the construction of the exceptions and how they interrelate with the seaworthiness obligation in that case. It's if you change one of the parameters, so if you change the parameter of an obligation to exercise due diligence at the beginning of the voyage to a continuing obligation to exercise due diligence, you can't assume that the other parameters are going to remain the same. So if you do say they remain the same, then you're going to have quite a difficult argument as to whether the cause is the failure to exercise due diligence or a navigational decision. Much more of a tension between the due diligence obligation and the contractual exception, which would need to be resolved as a matter of construction. So, Lords and Lady, if I could then take you to a number of the cases that Learned Friend relied on. And what I've done is I've taken you to the fundamental cases that establish the principles that are understood to apply in the Hague Rules cases. The cases that my learned friend relies on are sort of a rather mongrel bunch, if I can put it that way, on the outer edges of the concept of unseaworthiness. We can go to the Taripo first of all, which is at bookmark 89.
Page.
I'm so sorry, it's page 1527. So it's page 1527, bookmark 89. And, I don't know what it is about unseaworthiness cases. Just as in the Madras case, there was a considerable complaint about the pleadings. There's quite a lot of complaint about the pleadings in this judgment of Mr. Justice David Steele as well. The starting point is that Cargo's pleaded case on passage planning was that the vessel was unseaworthy because there was no proper passage plan in place. And we can see that at page 1532. This is setting out an extract from the particulars of claim. Top of the page, the relevant passage containing the allegations on seaworthiness is, as initially served, was notable for its lack of detail. It read as follows, and then the particulars are set out. At C, halfway down the page, it was pleaded there was no proper passage plan for the part of the voyage during which the grounding took place. So there was a plea there that is consistent with our case, that the absence of a passage plan or the absence of a proper passage plan can of itself constitute unseaworthiness. Now, in that case, the court held that the passage plan was not defective. You can see that at paragraph 99. Page 1541. This is considering the pilot's passage plan, which was the passage plan that was brought on board by the pilots and which was being used at the time of the casualty. Paragraph 99, the judge says, in any event, I'm not persuaded that the pilot's passage plan would have been condemned as deficient by any competent mariner as a consequence of the absence of these three annotations. So anything that is said about the possible effect of a defective passage plan is obiter, because the material finding, the ratio in relation to the passage plan, is that it was not defective. There's nothing in the judgment in my submission to support the suggestion that if the passage plan had been defective, that would not have been or would not have constituted unseaworthiness. There's no suggestion in the judgment that the pleaded case that we've looked at, that the defective passage plan constituted unseaworthiness, was wrong. And indeed, if we look at paragraph 78 on page 1538, under the heading the law, it said that there was, unsurprisingly, no issue as to the law. So, on the face of it, there doesn't seem to be any point taken by the owner that, as a matter of law, a defective passage plan could not constitute unseaworthiness. What the judge said obiter, paragraphs 100 and 101, where the judge held that if the passage plan had not been defective, there would have been there was no failure to exercise due diligence in relation to its formation, nor was there evidence that the master and officers were incompetent. So we say that there is no support in that case for the owner's propositions in our case, that the high watermark of it really for owners is that it doesn't seem to have been argued, there's no record of it having been argued, that the pilot's failure, a failure on the part of the pilots to exercise due diligence in the preparation of the defective passage plan, had it been defective, would have constituted a breach of the ongoing obligation to exercise due diligence in that case. But there's nothing really to be you can't draw any conclusions from an argument that wasn't run on different facts in a different case. And it's notable that in both the judgment of Mr. Justice Tier in this case at paragraph 83, at paragraph 83 of Mr. Justice Tier's decision and paragraph 66 of Lord Justice Flo's decision, they observed that it's not clear how the classic test of unseaworthiness operates if there is a continuing obligation in relation to seaworthiness. I've sought in the answers to questions from Lord Hammond to explain how we say it would work, but certainly it's a different kind of case where you have a continuing obligation. That was an observation made by judges in both the courts below. So we say that the takeaway point from the Taripo is that the claimants had pleaded that the defective passage plan rendered the vessel unseaworthy, and there is no indication in the judgment that anyone argued that that was wrong as a matter of law. The debate or discussion obiter was in relation to due diligence. And so insofar as the first question is, can a defective passage plan render a vessel unseaworthy, there's nothing inconsistent with our case in the Taripo.
What do you say about the pilot-master exchange point made by Mr. Hill? How that fits into the analysis?
You mean specifically in relation to Taripo, or
no, more generally?
More generally, well, if you've obviously got to distinguish between the master pilot exchange at the load port and at the discharge port, because again you have the temporal issue there. So the master pilot exchange at the discharge port, if there's a failure, it'll be caught by 42A. Unless
I assume at the load port,
at the load port, and assume it takes place on board before the voyage commences. Well, if there has been a failure to carry out a proper master pilot exchange, such that the master and pilot are not ad idem as to what their understanding of the departure is going to be, or what the procedures to be followed are, then that is a state of affairs that constitutes unseaworthiness. Because quite clearly, I mean, if the SMS will stipulate that a master pilot exchange has to take place, and prudent owner would not allow his vessel to go to sea until that exchange has taken place. The absence of that exchange having taken place is a state of affairs which could constitute unseaworthiness. Again, it's obviously going to be a question of fact, because if if both have sufficient knowledge to enable the safe departure of the vessel without having had a formal exchange, as a matter of fact, it may be that the a prudent owner wouldn't require sort of formalistic MPX or the filling out. Perhaps a better example would be, let's say it takes place, but the relevant form isn't filled in. Is the vessel unseaworthy because the relevant form hasn't been filled in? Well, the prudent owner, as a matter of fact, may well say it doesn't matter that the pro forma hasn't been filled in because there has been a sufficient exchange of information. But if there hasn't been a sufficient exchange of information such that the master and the pilot cannot safely navigate the vessel together, then there's no difficulty in saying that that state of affairs constitutes unseaworthiness. It's a state of affairs which puts the vessel and the cargo at risk. But as I say, it's going to be a question of fact in each case. Yes, in relation to that, I think I've touched on this already. The authorities do suggest that a state of mind can constitute unseaworthiness. That's the disinclination point in the Eurasian dream. A disinclination on the part of master or crew to perform properly can constitute unseaworthiness. And if that state of affairs, or just the state of affairs, is the state of mind of the master or crew, so a state of affairs which is the lack of sufficient exchange of information between the master and pilot, that could indeed constitute unseaworthiness. And obviously, again, the different facts and different cases will vary. It may be that if it was established there was a consistent failure on the part of the master to carry out a proper MPX, that could be evidence of a lack of competence. So next we have the attributes argument, and it's necessary to look at the apostolos in relation to this. Firstly, we say if there is an attributes threshold, then it is clearly satisfied on the facts of this case, because the passage plan and the chart must be attributes of the vessel. If there's a relevant threshold test, then it's crossed in this case. We say that the attributes label doesn't advance matters, and it isn't really any sort of meaningful threshold test in any event, because as Lord Leggett suggested yesterday, if you apply the label and say that there's a threshold test of attributes, you still have to decide on a case-by-case basis whether the defect of the state of affairs is to be considered an attribute or not. My friend wasn't able to offer any principled basis for determining whether a particular state of affairs or particular defect would cross the threshold or not. As we've discussed already during the course of my submissions, there's a wide variety of states of affairs or defects that can constitute unseaworthiness. So you've got documents cases, the inadequate systems cases, where either the SMS doesn't set out proper procedures, or it does, but they're not enforced and implemented by the owners. You've got the ignorance on the part of the master or crew, either generally or in relation to a particular matter, such as the operation of the CO2 systems on the Eurasian Dream. You've got the disinclination to perform that I've just mentioned. You've got the trading history of the vessel, such as in the Camper case. So it's very difficult to attach any meaning to the word attributes if all of those different, varying defects and states of affairs satisfy an attributes test. Obviously, they weren't discussed in those cases themselves as being attributes of the vessel. We say simply it has to be a quality or condition or state of affairs relating to the ship, as opposed to something that is entirely extrinsic or external to the ship. Now, if you want to say, well, that satisfies an attributes test, so be it. Doesn't really advance the substance of the argument. We say that seeking to say that there is an attributes threshold is just applying a label. It's an unhelpful label in terms of developing the substantive argument.
Well, I think in the Eurasian Dream, one of the examples given by Mr. Justice Cresswell was the drunkenness of the master or the crew.
Yes.
Which indicates the breadth of his view of the concept.
Yes. I mean, if the master is drunk, then there is no doubt that the vessel is unseaworthy. As I say, they're not reported decisions in arbitration cases where a master who has formulated an intent has been corrupted and intends to deviate to take on drugs. The vessel will be held to be unseaworthy. But I mean, it's if you use the word attribute, it's rather hard to see the fact that the master has been corrupted as being an attribute of the vessel, and so we say it's not a helpful label.
Taking on drugs, that's a lawfulness point, is it?
Well, it's if the cargo can be put at risk, because if the master deviates to take on drugs and the vessel is then arrested, cargo isn't released. So
it is a lawfulness, not a physical safety.
Well, it can lead to physical risk to the cargo, because if the vessel is seized and the cargo deteriorates during the period of detention, so that bad intent can pose a physical risk to cargo, or can simply lead to delay in the conclusion of the voyage. In relation to attributes, the problematic one on the authorities, as I mentioned earlier, is the question of whether cargo, one piece of cargo in the hold, can render the vessel unseaworthy in relation to other items of cargo in the hold. And you've got conflicting Court of Appeal decisions in relation to that. You have the Apostolus, which holds that dangerous cargo doesn't constitute unseaworthiness. And then you've the Captain Sakharov, which holds that dangerous cargo does render the vessel unseaworthy. Now, we're getting, we can get ever further away from the facts of this case. My submission is that the right analysis is the analysis in both the Aquacharm and the Captain Sakharov, that the relevant unit, as was put in the judgment of Lord Justice Shaw, is the cargo and the ship and the cargo. That the Captain Sakharov is to be preferred to the decision in the Apostolus. I'm perfectly happy to develop that argument and to look at the Apostolus. If your lordships would like me to do so, it's not necessary for the decision on the facts of this case, but since there is that tension between two Court of Appeal cases, it may be something that your lordships wish to. But
in the Apostolus, the cargo was on fire, wasn't it?
Yes.
It wasn't a dangerous cargo in the sense it was one that could explode. It was on fire.
The cargo was on fire. There are two stages to unseaworthiness in the Apostolus. The first is the fact that hot work was taking place, causing sparks to fall into the hold. And the Court of Appeal say the judge was wrong to say it was a rain of sparks. It was less extreme than that. But the first question is, does the activity of the hot works cannot render the vessel unseaworthy? And the Court of Appeal said no. And then the cargo was then set on fire. And the question was whether the cargo being on fire made the vessel unseaworthy or not. And the Court of Appeal said no. And in my submission, if you've got cargo on fire in a hold, that hold is undoubtedly unseaworthy for other cargo, because you're not going to put your cargo into a cargo hold where other cargo is on fire. and particularly if you consider the relevant unit to be the ship and the cargo together, that the unit is unseaworthy. In the Apostolis, a lot of reliance was placed on the case of the Thorsa, which is the chocolate and the cheese case. And it was held that in that case, I think chocolate was loaded on board first, and then subsequently cheese was loaded, and the cheese tainted the chocolate. But actually, if you look at the three judgments in that case, that the ratio is based on the doctrine of stages, because the chocolate went on board first. And at that stage, it was just an empty hold with no cheese in it. And the empty hold was perfectly cargo-worthy to have the cargo of chocolate put into it. What then happened was that the cheese was put in. But because of the operation of the doctrine of stages, that was simply a negligent act rather than a breach of the warranty of cargo-worthiness in relation to the hold. Because when the chocolate had gone into the hold, the cheese wasn't there, so that the hold was cargo-worthy. But in my submission, it's not necessary to go back and analyse chocolate and cheese cases from the 19th century to find the answer, which is that if you've got dangerous cargo on board that puts the other cargo and the vessel at risk, that must constitute unseaworthiness in the unit that is the ship and the cargo. As I say, anyway, that's one of the issues that's unresolved on the authorities, and is that the outer edge of the concept of unseaworthiness, and not relevant for the purposes of today. Or certainly, I say not relevant, certainly not necessary to be decided for the purposes of today. And where it is relevant to the question of attributes is obviously in deciding that the cargo on fire didn't constitute unseaworthiness. The Court of Appeal said doesn't constitute unseaworthiness because it's not an attribute of the ship. That sort of begs the question: what's the relevant unit? Is it just the ship absent the cargo, or is it the cargo and the ship together, as Lord Justice Shaw said in the Aquitron?
What had the first instance judge found about the cargo on fire in the Apostolis? In the Court of Appeal, they seem to be directing to his finding that the welding was vessel unseaworthy, which yes. The answer was it was just a small piece of welding. It didn't alter the state of the ship.
Well, the judge had found that the welding was the cause of the fire in the cargo, and the Court of Appeal overturned that finding of fact, holding that it wasn't established that the welding was the cause of the fire, as opposed to a discarded cigarette being the cause of the fire.
But had he found that the cargo being on fire as a result of the welding made the ship unseaworthy?
I've got a brain freeze as to what the judge found in relation to that.
Because the focus on his judgment seems to be criticising him for saying that there was a rain of sparks.
Yes,
from the welding, and his basis seemed to have been that carrying out welding made the ship unseaworthy. It's obviously more problematic if it was just a small piece of welding that went on.
Yes.
The Court of Appeal said that was no different from smoking a cigarette or something on board the ship. It didn't make it unseaworthy.
Yes.
But then it seems to, then Lord Justice Phillips also analysed the cargo being on fire, but I wasn't sure whether that had actually formed part of the decision at first instance.
No, the criticism for the judge saying that there's a rain of sparks, in my submission, is a slightly odd criticism, because if the activity causes a material risk of fire to the cargo or the vessel, it's hard to see why the extent of the number of the sparks matter. If the activity that is taking place on board means that it's unsafe for cargo, then in my submission that should constitute unseaworthiness, because there's a danger present on board that means that it is not a safe place for the cargo to be. The first instance judgment is in the bundle. It's at page 122. Lords, if we look at page 895, which is in the Court of Appeal, I think the analysis that the judge found that the work itself made the vessel unseaworthy. I think a fortiori, if the cargo is on fire, that must be unseaworthy as well. It's at the bottom of the left-hand column. On the facts which he found, the judge held the owners were in breach of Article 3.1 because the vessel was unseaworthy on the ground that the cargo was exposed to the risk of fire. And in my submission, that's the right analysis. Well, that's what I wanted to say in relation to the Apostolus. The Hill Harmony was one of the other cases relied on by my friend. That's not an unseaworthiness case at all. It's to do with the dividing line between employment and navigation under a time charter. The word unseaworthiness doesn't appear anywhere in the judgments in the House of Lords, and it's just not relevant to this case. The point for which it is relied, as I understand it, is that it suggests that there may be acts of navigation that take place before the beginning of the voyage. That given the concession that is made, paragraph 107, the written case, that navigational decisions can cause unseaworthiness, that's a point that just doesn't go anywhere. And it's illustrative of the submission I made earlier, that concessions are made, but then arguments are developed as if the concession hadn't been made. Because once it's accepted that negligent navigational decisions can cause unseaworthiness, it doesn't matter whether navigational decisions can be taken before the beginning of the voyage or not. Well, that's what I wanted to say on the authorities, the English authorities relied on by my learned friend. In relation to the Travaux, we say that essentially a bullseye is required for the Travaux to be relied on, whether you are looking at determination of meaning where ambiguous or confirmation of meaning where not ambiguous. There's no principled reason for having a different test as to whether you can rely on the Travaux in those two different circumstances. There's nothing in the passages that you were taken to by the learned friend, or those that was referred to in a scale of no argument, which assist his analysis. The passages that he took you to really do nothing more than indicate that the ship-owning interests wanted their negligent navigation exception to apply to the Article 3 as an exemption to 3.2. But obviously we see that from the rules themselves. There's nothing to support any argument that negligent navigation and management cannot constitute unseaworthiness and thus 3.1 liability. and nothing to support the view that navigational decision cannot constitute unseaworthiness, or that there's any difference between ensuring that the right chart is on board or correcting the chart and marking the warning on the chart. We do say that the travaux provide a bullseye to the effect that the intention was that the 3.1 obligation was subject to a temporal cut-off, but not to any category-based limitation. And we can see that at bookmark 102 at page 1677. And this is a discussion in 1921 in relation to Article 3.1a. And the question is raised as to whether the seaworthiness obligation, the due diligence obligation, is going to be a continuing one. And Sir Norman Hill says at the foot of the page, Mr. Chairman, the words in the Canadian Act are to make and keep. Those are not the words in the Harter Act. As I understand it, and I think is as the cargo interests generally understood it, the obligation in regard to seaworthiness is up to the time of starting the voyage. To begin with, before you start loading your cargo, you must have a seaworthy ship, a ship worthy to take that cargo. And when she leaves on the voyage, she must still be seaworthy. That sort of reflects the doctrine of stages that is rejected by the Privy Council in Maxine Footwear. If you go further than that and you say that there's an absolute obligation on the part of the ship owner to keep the ship seaworthy throughout the voyage, then of course you render quite valueless most of your exceptions. For instance, if through the negligent navigation of the pilot the ship is run on the rocks and hold, she ceases to be seaworthy, there cannot be an overriding obligation on the ship owner to keep the ship seaworthy throughout the voyage. He is excused, and we all agree, as I understand it, that he should be excused because the damage has been done through negligent navigation. When this was drafted, I think all of the interests clearly agreed that the obligation, and the only obligation they wanted to put on the ship owner, was that the ship should be seaworthy when she starts loading, that she should be seaworthy when she starts the voyage. If that has been done, he has done his duty, and then the voyage is made under the conditions set out in number 2, and with the exemptions set out in Article 4. So it supports the proposition that there's a temporal limitation on the seaworthiness obligation, but no category-based distinction, because the exemptions set out in 4 apply during the voyage. When the voyage is made, it's under 3.2, and with the exemptions set out in Article 4. And there is also a bullseye that the 4.2 exceptions don't, a further bullseye in relation to the fact that the 4.2 exceptions don't exempt from 3.1 liability. That was the position, obviously, that was understood at common law, and it's to continue. We see that at 1718.
You are keeping an eye on your time, Mr.
I am indeed, yes. We've because of the slight loss of time this morning, we've agreed that I'll stop at about 15:33 or thereabouts.
You obviously have a very precise passage planned.
We noticed when you came back in, we didn't notice exactly when you went out, so there's a bit of fuzziness around the edges. Perhaps I can invite the court simply to read the paragraphs below the numbers 144 and 145. So that clearly supports the proposition that the 4.2 exceptions don't apply to 3.1. I said at the outset I would say something about the insurance position. I think I probably covered that earlier in my submissions in relation to the fact that insurers already have to cover some liability for damage to cargo. That leaves the US cases. It's said that there's a consistent line of US authorities, but in fact, to the extent that they're relied on, it's really to establish principles that don't apply as a matter of English law. We say that the US authorities don't recognise the category-based distinction, or a distinction between a failure to make the ship safe to be used and the crew's failure to use it. To the extent that they did establish such a principle, it's obviously contrary to the well-established principles of English law. I'm going to take you to one US authority, it's the Supreme Court decision in International Navigation and Farr and Bailey. In that case, the Supreme Court, as we'll see, expressly rejected an argument that the carrier's obligation is only to provide proper structures and equipment. The carrier is not liable for the crew's failure to use that equipment. The court held that a carrier cannot rely on the exceptions for errors in navigation and management, and the consequence of the error is to make the ship unseaworthy before the commencement of the voyage.
Could you give us a page number for that?
Yes, I'll take you to the decision itself in just a moment. The reference is.
Yes, when you're ready.
Yes, I'm grateful. What I wanted to do first was just to look at a further warning in relation to the use of US cases in the judgment and the speech of Lord Wright in the Monarch steamship case, which is at bookmark 45, page 622. And the relevant passage is at 656. I'm sorry, I may have got the wrong reference.
It's at the foot of the page, I think. Penultimate line.
I'm so grateful. Yes. Indeed.
Bottom last two lines.
Yes. Yes, indeed, and that's right. And he goes on to so he notes the point that I was going to make, that obviously the decisions of the Supreme Court are binding on the lower courts in the US. In the US, the appeals courts are not binding on courts of coordinate jurisdiction, and are not binding on inferior courts in other circuits. And there are further difficulties there set out at 657. Now, to a certain extent, some of those difficulties are alleviated by increased technology and the ability to find US cases. But obviously what you're not being presented with is a comprehensive review of the US authorities and the US law. And cherry picking sounds like a terribly pejorative term. I don't intend it to be, I don't use it pejoratively, just to describe the exercise that has taken place. Because my learned friend has put a small number of US authorities into his case, but it can't purport to be a comprehensive review of the law in the US, and can't purport to set out all the relevant cases. And as an example of that, his analysis didn't include the Supreme Court decision in international navigation. That is at tab 92, or bookmark 92, in the bundle. at page 1585. It's a Harter Act case, and it's another porthole case. Seawater entered through a porthole which the crew had left unfastened and caused damage to a cargo of fabric which was being carried from Liverpool to Philadelphia. On appeal to the Supreme Court, Carrier argued that the failure to fasten the port covers was a fault or error in the navigation of the vessel and therefore exempted pursuant to the Harter Act. And the district judge thought that the vessel was unseaworthy, but felt that he had to yield to a previous decision in a case called the Sylvia. If we look at the head note, first of all, on page 1585, the Supreme Court say that the Harter Act, so-called, does not relieve the ship owner from liability for damages caused by the unseaworthy condition of a ship at the commencement of the voyage, nor is the ship owner exempted from liability under that Act for damage or loss resulting from faults or errors in navigation and the management of the vessel, unless it appears that she was actually seaworthy when she started, or that the owner had exercised due diligence to make her so. The mere fact that the owners provide a vessel properly constructed and equipped is not conclusive that the owner has exercised due diligence within the meaning of the Act, for the diligence required is diligence on the part of all the owner's servants in the use of the equipment before the commencement of the voyage and until it has actually commenced. The law recognises no distinction founded on the character of the servants employed to accomplish that result. Whether a ship is reasonably fit to carry her cargo is a question to be determined on all the facts and the circumstances, and the difference in the facts of this case from those in the Sylvia was such that the Court of Appeals was at liberty to reach a different result. My Lords and Ladies, that passage in the head note of the Supreme Court case in the United States is about as succinct a summary of our case and the submissions that we make as you could ask for. And so to say that there is some consistent line of authority in the states that undermines our position and supports the owner's position is just not right.
It treats seaworthiness, I haven't read the text yet, but seaworthiness as an overriding obligation.
Yes, indeed. It's on all fours with Maxine footwear and the Muncaster Castle, albeit in the context of the Harter Act rather than the Hague Rules. And the relevant, I haven't got time to take your lordships to them now, the relevant passages are at 1590 through to 1593. And there is a very thorough analysis there in the opinion of the Supreme Court that is absolutely on all fours with the leading English authorities and with our submissions. You know, you were taken to a passage in the Jala Javier where there's an obiter comment made very much en passant. Actually, if you look at it, it's not entirely clear whether it's an observation that the court is making or a recording of a submission that was made. That was one particular Court of Appeals, I think it's the Third Circuit. We were taken to the Portland Trader, which is a district court decision, so it's a first instance decision in one circuit. Those cases certainly don't establish any consistent line of authority that should be followed in the interests of harmonisation of the rules. To the extent that some cases in the US have gone in a different direction, well, there we are. That sometimes happens. The English principles are clear. I think I'm just about on my time deadline. Unless there are any further questions, which I can assist the court, those are the submissions I wanted to make.
I think not, Mr. Russell. Thank you very much indeed for your submissions. Mr. Hill.
Can I start Can I just start with that last point in relation to international shipping and fire? Can the court note that this was under the Harter Act, and under the Harter Act, at that time in 1902, an error in management that damaged cargo, could not apply before the commencement of the voyage. So, for example, if you were just loading the cargo and you damaged the cargo, at the time in the US, an error in management couldn't protect you from your bailment obligation. And that infects the whole case, and it's now been overturned, essentially. But I'll move away from the American cases. If I can go back to the facts of this case. My learned friend spent a lot of time on the facts of this case and asked you to look at the judgment of Mr. Justice Tier. And I'm going to do the same again, but a little bit more briefly. If the court could turn to tab 7, page 148 for the judgment. If we can pick it up, please, at paragraph 25, which one sees on page 155. The judge there records that the passage plan was contained in two documents, the pro forma passage plan and the working chart. And he calls it specifically the working chart, not the published chart. And you'll see in paragraph 26, he says the first document, and that is the pro forma document, and he puts that in speech marks, the passage plan, consists of 5 pages. And what he does is one has to be careful when one reads throughout the judgment thereafter what he's referring to, because when he refers to the passage plan, he quite often refers to the 5-page pro forma. When he refers to chart, he's normally referring to the working chart, not the published chart. Now, in paragraphs 27 to 29, he discusses the pro forma. And if one goes on to paragraph 33, you'll see that he says there was an issue as to whether there was marked on the chart any no-go areas, that is, areas where it was not safe for the vessel to go. The conventional way of doing so is by marking such areas by means of a hatched line. He then says at paragraph 63, which is on page 162, he says the dispute was manifest from the oral evidence of the area. It was not so manifest from their written reports because Captain Hart did not in terms articulate in his report the precise form in which the no-go area should have been identified on the chart. So essentially this all became an issue that was raised for the first time actually in the oral evidence because it wasn't in Captain Hart's report. Now, then if one looks at paragraph 66 over the page, we looked at it briefly earlier, the judge says, the question in the present case was as to the manner in which it was prudent to note the danger identified in the notice to mariners. And he records Justice Steele's response in the Repo about it not being a science, and he says, passage planning is not science. There is inevitably an element of judgment as to what annotations need to be added. And clear, we say, from it's clear beyond doubt from that paragraph alone that how one prudently notes the danger referred to in the notice to mariners is clearly a matter of passage planning. We then have at paragraph 67, he refers to the fact that Captain Hart, my learned defence expert, said the areas outside the fairway should have been hatched on the chart, and that was...
You've drawn attention on a number of occasions to the fact that there was a dispute about whether it should be marked with hatching or some other way.
Yes.
I've yet to discern any possible relevance in this dispute.
I was just going to deal with that, so maybe if now's a good time.
Well, better late than never, I suppose.
Well, I apologise it wasn't earlier. The position is this. if one just takes it up, if one can ask the court to just turn to the IMO guidelines again at 298. And if one looks, well, we'll start actually at 299. When you are doing the appraisal for your passage planning, it's on the base. It says it's on the basis of the above information. An overall appraisal of the intended voyage or passage should be made. This appraisal should provide a clear indication of all areas of danger, those areas where it is possible to navigate safely and the like. And it starts with on the basis of the above information. So what the master has to do, or the officer, is he looks at a second officer. He takes into account all the factors in paragraph 2.1. And for example, the condition and state of the vessel, her stability, her permissible drafts in the seaway, for example, in ports and in seaway. He then has to take into account routing guides, and he has to take into account climatical and hydrographical and oceanographical data. He has to take into account weather and things like currents and tides. And in the light of that, he has to, for example, mark no-go areas. So I'll give an example to my Lord Legate. If you are a smaller vessel and you leave port on a high tide, you'll have absolutely no problems with certain shoals. If you're a much deeply laden vessel, a big container ship, and you're leaving port on a low tide, you won't be able to go to certain areas because of shoals. And your hatching out in your no-go area will depend on you making a judgment in relation to all of these matters and hatching out what is for your vessel on that voyage at that time, whether it be in the morning or night, what is an appropriate no-go area. Now, what we say is that these factors at pages 298 and 299 are all navigational factors that he takes into account. And whether he takes this into account and he hatches the wrong area, or he takes it into account and hatches the right area, is essentially a navigational decision. If he gets it wrong, it's an error in navigation. And what we say is, why should that matter? Why should there be a difference? As if he chooses to hatch it out and he makes a navigational error in part of his decision-making process, why should the result in this case be any different because he hatches it out, or because, as the judge found, you could have written a warning at the top of the chart saying, be careful, depths can't be relied upon. The result shouldn't change depending on whether you've chosen to hatch out to mark no-go areas, or you put the warning at the top of the chart.
But it doesn't, does it?
Sorry?
The result doesn't change, does it?
No, we say it shouldn't change. It doesn't change.
But is anybody suggesting it does?
Yes, because my own friend says the chart is defective because it doesn't contain the warning. And we say, and he says it's because the warning isn't reflected from the notice to mariners. And what we say is that is simply part of passage planning, and part of passage planning can include hatching out areas on a chart. The chart, nobody would say the chart is defective or unsafe because you've hatched out the wrong parts on the chart. The base chart isn't, or published chart is defective, we say. What would be defective would be the passage planning process and the navigational decisions that has led to that. My little friend used in, I think, in answer to a question from the court, he considered another example. He said, what happens if the master selects the wrong chart from the chart box, the correct chart being on board? Mr. Russell said that the vessel would then be unseaworthy if the passage planning had been done wrongly. We suggest that demonstrates the fallacy of the argument, that the erroneous use of equipment renders the equipment defective. Plainly, the appropriate chart that in Mr. Russell's example he used the appropriate chart which the master should have selected cannot, on his example, be rendered defective because the crew's failure to use it. The correct chart he should have used isn't defective. Similarly, the wrong chart is not defective. It was just the wrong chart that was used and taken out of the chart box. So what we say is this draws, in a way, nicely draws the distinction between, on the one hand, equipping a vessel so that she's got everything she has to be safely navigated, and the act of navigating, and in particular the navigational decisions made by the master, which we say are in a different category and do not form the basis for a finding of unseaworthiness. The next point I'd like to deal with is my Lord Legate actually put a question to Mr. Russell, and it's in the transcript at page 160, lines 222 and 225, which is there might be a distinction, though mightn't there be, between information that we're dealing with here that ought to be recorded on the chart about depths and the sort of example Mr. Hill was giving of what is essentially a provisional decision to travel at a certain speed. And if I can deal with that, Mr. Russell accepted there may be a distinction, but he said you don't need to determine it here because we've simply got a defective chart. Now, if I can just deal with that distinction, we say there is a distinction for the reasons I've just given, but I'll accept the premise of my Lord Legate's question. We say the answer that a prudent owner will give is going to be the same whether it's a lack of information or erroneous instruction. We say the answer a prudent owner will give is going to be the same regardless of whether the passage plan is defective because it lacks information or is defective because it contains a wrong instruction. And if executed, therefore, the vessel will inevitably ground or collide with the side of a bank, for example. The prudent owner would in either case wish to remedy the defect before sending the ship out to sea, on my learned friend's case. So we say, in short, if the only test is the prudent owner test, which cargo interests advance, then this appeal will predetermine the outcome of cases that concern not only lack of information type cases, but also wrong instruction type cases as to speed or route. Because on my learned friend's approach, it doesn't matter, you just apply the prudent owner test. Indeed, we say even if this appeal is decided on the basis that the absence of such information renders an attribute of the ship defective, whether one calls that the attribute a passage plan or a chart, that very same attribute will be defective if it's, for example, the speed and route type cases. Therefore, we say the answer the court gives to the depth warning / no-go area scenario, which is the one concerning our case, will necessarily also need to apply to other potential defects in a passage plan. Even if there is a theoretical distinction between those two aspects of defective passage planning, the ones my Lord Legate gave, between absence of information and erroneous instructions, even if there is a theoretical difference between those two, in practice the outcome will be the same. In fact, on this approach, we say there can be no principal distinction as a matter of seaworthiness between a depth warning and the absence of a depth warning and a provisional speed example given by my Lord Legate. Can I deal next with the issue of navigational tool? Mr. Russell sought to emphasise that a passage plan is a navigational tool, and we disagree, and our argument has essentially 3 steps. Step 1, passage planning is navigating, as it consists of a set of navigational decisions. Step 2, the navigating officers will have regard to this set of navigational decisions whilst navigating. To that extent, the plan could be labelled a tool. Step 3, however, the reason it is not a tool when the carrier, the reason it is not a tool which the carrier has to equip or supply the vessel is that you don't need a passage plan to create passage plan. And I'm going to unpack that in a moment. As SOLAS makes clear, the carrier's duty is to provide charts and nautical publications, and for the master then to use them to passage plan. And my clients did that. Now, if I can just unpack step 3. A passage plan is created by the crew using equipment on board the vessel. So long as the ship is competently manned and properly equipped, the crew will be in a position to create a non-defective passage plan. It's common ground that the Libra was equipped, such as to enable her crew to create such a non-defective passage plan. Therefore, all the tools the crew needed to navigate were provided. And it's no answer to say this tool is some special tool which was additional that the crew couldn't provide.
That's not the test. The test is whether it's a tool they should have had on board. And the fact that you could make it from other tools does neither here nor there. If you've got a competent crew, they could go and shut the porthole before the cargo is stowed so as to obstruct it.
Exactly. And because you don't, you've now got not a porthole that can or cannot be opened or shut. You've now just got a hole in the side of your vessel, because once you stow cargo in front, it becomes an attribute of the ship. And therefore, it's not a porthole, it's just a hole. The thing about a passage plan is that the crew has, essentially the crew chooses, or the master and second officer chooses to make a series of navigational decisions early for very good reasons. And there's, as I said before, very good reasons why passage plans are required. But in the end, they're just a series of navigational decisions which the crew has made. And the fact that it's now been written down as a set of navigational decisions and will be used in one sense by the crew when navigating doesn't turn a set of navigational decisions into an attribute of the vessel. Maybe if I can expand it this way. It's worth looking at it in the context, for example, of a continuing obligation of seaworthiness. Now, they are common in shell time for charter parties. It was in the Terepo. The Terepo was a case of a continuing obligation of seaworthiness. The bill of lading incorporated provisions such that it was, and that's paragraph 123 of the judgment in the Terepo. Now, a passage plan is said to be a navigational tool because the navigating officer will rely on the master's navigational decisions as recorded in the passage plan during the voyage. That's the reason why it's said to be a navigational tool. However, there is no difference, we say in principle, between the master telling the navigating officer his defective decisions 5 hours beforehand, before they have to be actioned, by writing those decisions down in a passage plan. There's no principal difference between that and, secondly, the master being on the bridge at the time of the decisions are made and telling him the same thing directly. There's no principal difference between that. In both cases, the navigating officer is relying on the master's navigational decision as a tool in navigating the vessel.
But what if the shoal is sort of 500 yards outside the harbour gate? You haven't had time to give all these instructions, work it all out with your ruler. You've got to do it before you leave the port.
Oh, I agree. I agree. And that, in a sense, that makes, my lady, that makes the point even more starkly, which is you make these decisions beforehand, before you leave, and they are navigational decisions the fact that you've made it and you're now just going to apply it immediately doesn't stop it from being a navigational decision rather than seaworthiness.
That's quite the point I was making. It might be too late once you've made the decision. You might have hit the shoal.
Yeah, well, I think I am going to, I hope I'm going to answer your point. The point is this. It's good to make it before you leave, because then you can think about it, you have time, you can think about it and check it's right. But if you don't make it before you leave, and as you leave you make that decision, you're going to take that course and it takes you over the shoal, it's still a navigational decision. Nothing's changed, it's still an error of navigation. The fact that you've written it down an hour before you've left shouldn't make any difference.
Well, it does, though, as a matter of practice, because it seems to be now recognised and found as a fact that a ship isn't seaworthy if it hasn't gone through this process of planning and prepared the aid memoir, or whatever you like to call it, or the tool, before it sets out.
And my lord, what we would say, one has to be careful what the finding of fact is. It hasn't been, it's a legal issue. We accept the finding of fact that a reasonably prudent master would, when producing a passage plan, write the depth warning on the top of the chart or do the hatching. Could have been done either way. We accept that. But whether that renders the vessel unseaworthy isn't a finding of fact. That's a finding of law. And
no, but you accept, don't you, as a matter of fact, that if the vessel had set out without a passage plan, it would have been unseaworthy. You can't just leave it to decide a few hours in advance. It's regarded as an essential aid that you have an advanced plan of your provisional decisions that you consult and use for subsequent decisions.
No, I think my answer to my Lord Bridges' question yesterday was I don't accept it's unseaworthy. What I say is, per se, my position is that actually, if you didn't have a passage plan, you still would not be unseaworthy merely because you didn't have a passage plan, because it's just a set of navigational decisions that have been written down, and it's not an attribute of the vessel. What I did accept yesterday is that if in these days, or frankly 30, 40 years ago, if you don't have a passage plan at all, there's going to be an inevitable inference that the systems that the owners had put on board the vessel were defective. And if the systems are defective, I accept then the vessel will be unseaworthy. But it's in answer to my Lady Arden's point, which is it doesn't really make any difference. Let's say the shoal is 500 metres outside the port. It really doesn't make any difference in terms of whether the vessel is seaworthy or unseaworthy, whether the decision to go over the shoal was taken as you're navigating over the shoal as you've left the port, or whether you've taken it a few hours earlier when you've drawn off the line on the chart. It's still a navigational decision. It was still wrong. It's still an error in navigation. I've only got 2 more minutes left, so I'll really restrict my comments in reply. The two... I'll go to this one. The two most important cases my learned friends rely on, the Maxine footwear case and the Muncaster Castle case, and they say those are the two most important cases. As regards to the Maxine footwear case, one just has to step back, and what we do is ask you to look again at page 607. I'm not going to ask you to turn it up now. That case is a very short decision, and it turned on the peculiar facts of the case. As Lord Somerville said in that case, from the time when the ship caught fire, she was unseaworthy. This unseaworthiness caused the damage to and the loss of the appellant's goods. The negligence of the respondent's servants, which caused the fire, was a failure to exercise due diligence. Now, on the particular facts of that case, the fire was caused by heating or trying to defrost a pipe, which the crew used an acetylene torch. Now, but it makes no difference if it was a lightning strike or a stevedore's cigarette. The short point is that the vessel is not fit for purpose because she was on fire. Now, my learned friend said in that case that Mr. Donaldson, he was a junior at that point, actively relied on Article 4.2b fire exception to exempt the ship owner's liability. And that is right. Mr. Donaldson, as he then was, did so, and he sought to argue that Article 4.2b fire exception was an exception to Article unseaworthiness under Article 3.1. He says that was a category-based distinction between seaworthiness and fire. It was not. It was simply saying the exemptions applied, and they don't, and that's what Maxine Footwear says. We accept that if a fire or negligent navigation causes the vessel a defect in the vessel, which is an attribute of the vessel, or causes her to be unseaworthy by reason of a defect which is an attribute in the vessel, we accept then that if that is, as I said, an attribute or an innate quality of the vessel, then the fire or the negligent navigation is just part of the causational background. And my learned friend at that point, it's worth mentioning, my learned friend keeps going back to this supposed concession we've made at paragraph 107 of our written case. And there's no concession there at all in paragraph 107. We've always accepted that, for example, if a vessel is negligently navigated coming into berth and she strikes the side of the jetty and causes a crack in her side of a vessel, then the owner and the master can't just leave it and go off to sea and say thereafter when they go off on the next voyage, oh well, we're not unseaworthy because this was caused by negligent navigation. What happens is there is a crack in the side of the vessel, that's a defect in the vessel, and the fact that it was negligent navigation is just part of the causational history. And that's all we said in paragraph 107, and we say it's patently clear when you read up paragraph 107 in context, because we're dealing with the other examples, my learned friend's examples. In his case, he had put before the Court of Appeal, which was the other cases such as the Thorlock and the Evgy and Dobell. But what we have in this case, and this is why this case is so novel, we have here a set of navigational decisions, either one or a series, which are themselves said to be the unseaworthiness. The navigational decisions are themselves said to be the defect and the attribute of the vessel, and not just part of the causational background. And that's the big difference. There is no, and therefore we go back to, you have to decide the attribute question first, which is, can navigational decisions basically be an attribute of a vessel and therefore cause a vessel to be unseaworthy? I really have run out of time now, so I won't make my other points.
Well,
but I'm grateful.
We have your argument, I think, pretty clearly in mind.
I'm grateful.
Well, we're most grateful to both counsel who've addressed us and also the many others who've no doubt contributed to the arguments that we've heard. We're most grateful. We'll now take time to consider the argument, and we'll let you have our judgment in due course.